And welcome to the Virtual Business Owners Network on Friday, March the 8th, 2024. And I'm delighted to introduce Gillian Traynor from Ambit Compliance, who will be talking about the whole area of compliance. And so I'll say, take it away, Gillian.
Many thanks, Alec. Thanks so much this morning to join me in talking about managing data protection risk in 2024. So I'm going to hone in on three particular risks. And I know most of us now at this stage are quite familiar, or at least I anticipate we are, with the GDPR and data protection legislation, because it's almost 6 years in the making, and the GDPR is. So we're going to just hone in on a couple of areas of what we see as risk, and talk about those. There'll be some opportunity to talk at the end if you have any questions or answers. Questions to ask me, and indeed if we don't have enough time, feel free to reach out to me. I'd be happy to discuss anything with you, any concerns you might have. So we're going to talk about data breach risk. We're going to talk about supplier risk and AI risk. Now, generally, I'm talking predominantly here around personal data, but I'd like us to think of it also around our commercial data, because our commercial data is sensitive to us. You may not be breaching the GDPR by your commercial data being leaked, but that's not something you would choose to want to do. So let's talk a little bit about data breaches in the first instance. We're kind of familiar with what they are, but it is important just to understand that there are different types of them. Now, I'm sure indeed Graham will be going into some of this detail. There will be some sort of overlap in between what Graham will be talking about next week in terms of cybersecurity. But we would see cybersecurity as an example as one of the tools in the toolkit in protecting personal data. So it's not the only solution, because IT is sometimes seen as the only solution, but we'll talk about that. So what's a data breach? There are three different types. So confidentiality breach, an integrity breach, an availability breach. So confidentiality, probably what we're most familiar with, when something is accidentally disclosed or somebody gets unauthorized access to that data. That might be simply through an error, or it might be through a hack. Integrity means when a system is changed in some way. Sorry, this is popping on. I didn't change it. So when data is changed on the system, the integrity of the data is changed, and therefore that's a data breach. An availability breach then is where the data is accidentally or unauthorized loss of availability to that data. So I'm going to give you some examples of these types of things as we go through, and the kind of consequences to them. So what are the common forms of data breaches? We're all very familiar, but I just want to recap on this. So it's accidental disclosure. This means it might be, most commonly, I think we see through human error, somebody's putting people on the CC instead of the BCC, or indeed you're sending it to the wrong person. So you're typing in Gillian T, and it comes up with Gillian Tynan and not Gillian Traynor, and off it goes to the wrong person. The risk associated with that incorrect email may be different depending on what's in the email, and we can talk about that afterwards. Incorrect addressed postal correspondent, when you don't redact data, where you're giving data to an individual, but you don't redact the data of others, and where you inappropriately dispose of paper records. So somebody puts something into the recycling bin instead of the confidential bin. Unauthorized access, the criminal, the hacks that Graham will talk about next week, those type of ransomware, etc. And when we're talking in the healthcare industry, and we do a good bit of work in the healthcare industry, we talk about voice privacy. So you're going for a consultation, you do not want to be overheard in your consultation. And you should be afforded that as an individual, or your clients should, if you're in that healthcare or confidential, I suppose, financial space as well. Confidentiality and data protection is crucial. So how do some of these data breaches happen? Also through lost or stolen devices. Password and encryption is important. Social engineering and identity theft. Again, I'm going to leave that to Graham to go through next week, but phishing and smishing are the ways that we're quite aware of these things now. We get regular SMS messages every day in terms of trying to get us to put our personal data in. baiting and through websites that are in some way spoofed, and then cybercrime. So you might say, so data protection notification, if a data breach happens, and we'll talk about how you're going to mitigate these breaches and risks in a moment, but you do have obligations where there is any risk to the individuals. So they could be your customers, they could be your employees, the people whose data you're processing or you're safeguarding. If there's any risk to what we call their rights and freedoms, you have an obligation to notify the DPC, and you've got a 72-hour deadline to do that. The clock starts as soon as you become aware. So we often hear, particularly when our clients they've outsourced their IT function, the IT provider might come and say, oh, we've just done a check on your systems and we realize, so we're saying in March, we realize that somebody's been monitoring our network since last December. So the hack may have happened in December, but you've only become aware of it in March. So from the moment you become aware, the clock starts ticking. You don't always need all the details, as a lot of the cases with particularly IT and cybercrime issues, you may not have all the details. You may need a forensic consultant to come in to check out what's going on in the system. So you must make a preliminary report that those 72 hours are crucial. And if there's a very high risk to data subjects, sorry, I think there's some sort of timer on this, where there is a very high risk to the data subjects, you must let those individuals know straight away. A lot of clients will ask us, well, what about, can I just tell them as a matter of courtesy? You can indeed tell them, but you need to be mindful of the impact of that. The statutory obligation only kicks in when we have what we call a high risk. So in other words, that might mean risk to that they would have identity fraud, risk that they will be discriminated against depending on the type of data breached, if it was health data, religious affiliations, political affiliations, etc. So what are the potential consequences? I suppose, what is the risk here really? So the risk is the reputational damage to an organization should sort of any of the following happen. If the DPC comes in, is alerted to it, they may do an audit, they may fine you, they may issue corrective actions instead of a fine. So they may say, well, if you do all of these things, we'll just issue you with a reprimand. So it's like a rap on the knuckles. So the problem with data breaches is that there's also now under GDPR the possibility of individuals making a private claim against your organization for a breach of the GDPR or a breach of their rights under the GDPR. And there was one successful case that we've only seen to date that has only very recently gone through the Irish courts, was the case of Ballymaguire Foods. And indeed, I can send on some resource links after this. This is where Ballymaguire Foods, a food manufacturing company, misused employee data by using CCTV footage of an individual in a training session demonstrating how not to abide by health and safety rules. And he felt much aggrieved by this use of his data, naturally without his consent. And he claimed for stress, sleepless nights, ridicule from his co-workers, and he brought a successful claim to the courts. He was awarded not a very large amount by many people's standards. It was €2,000. But what Ballymaguire Foods had to pay in order to defend that claim, etc., is probably many, many times that. Plus, they're now in the headlines or can be Googled in terms of their reputation. It is a damage. So what was interesting about that claim is that, so that's a claim for non-material damages. So in other words, not a financial loss, but in some way a grievance because of stress. In this court case, the judge didn't actually ask for medical reports or evidence that this person was stressed or suffered sleepless nights or was in any way under pressure. He or she, I'm not sure which the judge was, took the defendant's, took the plaintiff's word for it. And I suppose that's the concern. Now this is just the first case of this type in Ireland. And as I say, we're nearly almost 6 years down the line in GDPR. What we do know in our work with clients and what we hear on the ground is that solicitors are very much aware of people's rights and will use data protection, particularly in employee scenarios, to fish for information, and will pursue these types of things through other means under the legislation. So they're the potential consequences of a data breach. I'm going to give you, I'm conscious of time now, so I just want to scoot through some examples. And I have taken all the tech giants out of any of these case studies because they're not very relevant to our businesses, really and truly, when we boil it down. There's certain key aspects that you could say could resonate, but people will rarely identify with a fine for TikTok or a fine for Meta. So the HSE has been fined in the past, numerous fines, in fact, and it has all been around the disposal of patient material. So again, the age-old problem of not disposing it in a confidential bin, not shredding it. A student working on site and going home with the paperwork and then dumps it in the recycling bin, and it's found then later in a public recycling facility and is reported to the DPC. So that's not to say that this couldn't happen to any one of us if we are dealing particularly with confidential or sensitive employee data or data of our clients. And likewise, would we want our commercial sensitive data that we work hard to produce and might be our intellectual property to be inadequately disposed of? I'm sure we wouldn't either. So something to be mindful of. The Central Bank of Ireland was a very interesting case because on the face of it, it didn't look like a data breach. So what happened here is the Central Bank of Ireland, they have duties to maintain the central credit register, and they have a duty after a number of years. I think the retention period in this particular case was 5 years, to keep certain data for 5 years, and after that, the financial records of credit registers of individuals must be deleted. But what happened was they kept it for 3 months longer because of an IT issue, 3 months longer than they should have. So basically, the data that was available was inaccurate, and also meant that people who would have had a cleaner credit register if it had rolled over as it should have done were now still holding on to the 5 years of data where it hadn't been reset. So we need to be mindful of, if we have legal obligations, particularly in the financial industry or employee law areas, that we are ensuring that if we have obligations to retain data for a certain length and then delete it, that we must do so. So this was kind of a special one in that the data was basically inaccurate, and it was then not affording people the correct rights in terms of their credit history wasn't reflective of what it should have been. They were fined quite a number, couple of 100,000, but it shows you that every data breach doesn't need to be a hack, doesn't need to be an IT failure. It can be not abiding by your duties to maintain the integrity of the data, which was the case. I like to present this case study as a data breach because it's largely unfortunate in that this is a charity that was fined by the DPC €1,500. So it kind of demonstrates that nobody is without outside the radar, I suppose, of the DPC. And at the same time, the €1,500 was sufficiently dissuasive, but it wasn't going to put the charity out of business. Basically, what happened here was Move Ireland are a charity that support men who are overcoming violence, who are aggressors in domestic relationships. And they work by means of employing facilitators for these counselling sessions, and they're sort of decentralised all across Ireland. The management of Move had hired these facilitators and given them all SD cards so that they could record the sessions for the purpose really of the facilitators being assessed in terms of their ability to provide this service. What happened was 40 SD cards were issued, and at the end of the year, they wanted all these SD cards back and found that there were 20 SD cards short. So they could not find them, and so they reported to the DPC. they were never found. And Move demonstrated or defended their case by saying, well, there's no evidence that these have been accessed by anybody. There's no evidence that they have been breached, really. They are just cannot be found. But equally, the DPC said, well, consequentially, yes, because there's no evidence, we have to assume the worst. So they were found to be failing on not having adequate policies and procedures, not having adequate controls for the type of data that they were handling. They weren't putting in sufficient controls given the high level of sensitivity of the data. So that's something that we need to consider when we're looking at protecting the data, you know, depending on what category it might be. So to finalize on the data breach side, ArcLife is an assurance company, as we're all familiar with it. They reported hundreds of data breaches to the DPC over a period of time. So the DPC went in to do an assessment of their practices to find out what was going wrong. They actually gave them a clean bill of health because they said that they had all the checking measures in place. They were doing spot audits, they were doing checks and balances, training of staff, etc. It was just the nature and the volume of what they were doing. There was going to be errors, and they gave them a clean bill of health and said that actually there was nothing more that they could have done. So it just demonstrates that not every DPC investigation goes awry, and not every DPC investigation ends in a fine. And it shows that when you demonstrate compliance, when you have the systems in place, when you have your training, which I'm going on to here, when you have your organizational measures, so that's training, policies, procedures, not just training in data protection, mind, training in how to use the systems that you have to use on a day-to-day basis, because that's usually where the human error comes in. Somebody just starts work, they don't know how to use Outlook, or they don't know how to use Excel when they're doing a mail merge, and the next thing, letters are going out to the wrong people because they sorted it incorrectly. Technical measures also equally important: hardening security, phishing exercises, keeping abreast of threats, as Graham mentioned, you know, being aware of what's happening out there. So in terms of supplier risk, we all use suppliers, big and small, whether that be a software provider or an outsourced provider who we ask to do something. So whether that be an outsourced IT, outsourced HR, outsourced payroll, you have ultimate responsibility as the data controller. When you're using a supplier, they are considered the data processor. You have the responsibility to ensure that they are compliant, that they have everything in place. So if you're sharing payroll data, are you sending it over in a secure manner? Are they sending it back to you in a secure manner? Have you an agreement with them as to how that might happen? If you're using suppliers on software systems, etc., outside of the EU, the UK, and the US, because there are protections in place for all of those countries. If you're using suppliers outside that, you need to ensure that there's certain contracts in place with them, that the data is protected, that they sign what's called standard contractual clauses to ensure that the data is safe, because the EU provides what we consider an adequate level of protection. The UK has also been given adequacy. So up until next year, they are okay. We're okay to proceed as normal without any additional agreements. And the US, the data privacy framework has been just concluded, and we need to check that suppliers are signed up to that. Again, if anybody wants to know any more about that, I can talk about it as an aside at a later point. Example of DPC fines where it's actually been the supplier or the provider's problem, but the data controller, like for example, Slane Credit Union, has taken the rap. All of these examples that I'm giving here, Slane, Centric Health, and the HR consultancy provider, they all suffered a data breach as a consequence of their data processor failing to do something. So in the case of Slane Credit Union, they were updating their website. The developer didn't put something in to protect the members area. So the members area was actually publicly available for a period of time. So these are the types of things. Naturally, you know, I'm just going to go on. How would you mitigate that risk? You do as much due diligence as you can. Send them a vendor questionnaire. in terms of what have their policies and procedures, what has their IT set up, etc. At least have an SLA or a contract with them. So you can say, this is what I'm asking you to do. And there can be no misunderstanding about what that is. So that if anything goes wrong with the data, hopefully that's what you've agreed with them to do and they're not doing anything outside it. Also, it is critical where they are processing personal data that there is a data processing agreement there. That can be an annex to your existing contract, or we'd like to see organizations kind of embed them, because it's very hard to get an organization to sign off on 2 documents at particularly, when people are anxious to get a service moving. Supplier audits. Also, if you have an appropriate data processing agreement, there's usually a clause in there that provides for you to do an audit on them. Now, naturally, you use Microsoft services or anybody else's, you have to sign their data processing agreement. There's no caveat or clause in there that'll say you'll be allowed to go, but there are possibilities, and you may, on the flip side, you may be asked to sign these data processor agreements, and just be mindful of what you're signing up to. Some, depending, they're all very similar, but some favor the data processor over the data controller, etc. So I suppose have a good look through what you're signing if you're on the flip side of that. So to talk about
Gillian,
AI.
Sorry, Gillian, we're heading well out of time.
Sure. Okay, I'm going to go to this, the last one, and I can share the slideshow.
Thank you.
So AI is, the big buzzword. We're all using it in one manner or mean of another. All I would just say is we need to be mindful. We need to understand what it is. We need to understand if our employees are using it, if we're happy that they're using it, what purpose are they using it for. Be aware of the upcoming AI Act if you are actually going to be buying AI programs that you want to use in your business. Also, when you're using software, like there's a little bit of controversy about DocuSign at the moment, that when you sign up, and you may either have to consent or not to consent, but you need to be aware that possibly the customer data is being used to train their tools. And as I noticed, some of us are using the AI companion for Zoom. If you are recording or using AI companion for Zoom, you must let your participants know so that they can consent or not consent, and you have to figure out how you're going to navigate that. So I'm going to share this slideshow with you guys after, and put on a few more links at the end, so you can look up some of those cases if you're interested. Thanks a million.
Listen, Gillian, thank you very much for giving us quite a comprehensive overview on a topic that I know you could run a whole half-day show on.
I know.
And I suggest to people to reach out, because we don't have time for Q&A here.
Sure.
But thank you very much again, Gillian, for doing that. So I'll just stop the recording.